Good evening, everyone. My name is Patrick Brutus, and I will be your host today, your co-host today with Robert McKay, and we represent Help One Save One, and you are watching a live interactive show on Channel 21 KNTV. Good evening, Chicago. Thank you for joining us this evening. Help One Save One is a community-inspired organization, and one of our main objectives is to educate and empower the community with information designed to inform and enlighten. As you've been watching us over the last few weeks, we have been discussing the 1968 Kerner Commission report and a number of different factors in the 50 years since and how that has impacted the black family. Today, we are going to be talking about family law and the impact of that. Now, with us, Robert McKay will introduce our guest, and we'll get to our discussion shortly afterwards.
Good evening. Hi, I'm Robert McKay, and today we have with us attorney Maria Barlow, who also recently ran in the primary for Cook County Commission in the 4th District. Was unsuccessful, but she made her name well known throughout the county. And she's a very forcible, formidable attorney, and we would like to question her and ask questions regarding the court system and family law. Maria?
Hi, good evening, everyone. Thank you both for having me. Always a blessing, always a pleasure to talk to people. So, if you guys have questions, I'm happy to answer them.
Well, one of the things, we started our series on the Kerner Commission report and how it unjustly depicts or positioned the black community. And it was identified in the Kerner Commission report that the black community is at a great disadvantage because of the system, the structured system that we are hostage to. So, and just recently today, I heard that there's a runoff in the circuit court for judges, 2 judges. There will only be 2 black. There's a campaign for 2 judges, and only one will win that election.
Yes.
And out of 17 circuit judges, there's only 1 black. Is that correct?
Partially. So what happens is a lot of people apply, usually several hundred. There's 17 seats at this time that were open for that application process.
Yes.
So we call it the short list. So
Yes.
the people who make the short list, and then there are people who want to make those seats. Out of everybody on the out of the several hundred people, all of the candidates boiled down to these 17. Okay. The last seat that's open is between 2 African American candidates.
All right.
So those 2 are campaigning against each other. So out of all the seats and all the people they could vote for, they only picked, and those 2 tied. So 1 African American will be picked out of that 17, which is a disparity, and it's unfortunate because we make up most of the people that interact with the court system.
Absolutely. And that does have a great effect on the family court when it comes to our community.
For sure. In this process, this application process, though, they're campaigning, but they're campaigning to judges. They're not campaigning to the public. So it's a lot different from
it's
a
internal
normal campaign.
Right.
Yes.
Right.
So the lawyers can't vote. Only the other judges vote. So
I understand.
It's kind of a popularity contest, if you ask me.
Popularity and some sort of bias in there built in.
I've heard that, too.
Yes.
It depends.
I've heard it and I've seen it.
So, Maria, let me ask you a question. With all that being said, as a black female attorney in Cook County and Chicago and Northern District, in a legal system where we are a minority within the minority, have you ever felt like your clients were getting an unfair deal because they were black or maybe of a lower economic status? Can you share and give us some insight into what you deal with on a day-to-day basis in the court system regarding family law and how that has impacted the black community?
For sure. Oftentimes, and I don't want to say oftentimes, but sometimes you do have a situation where somebody is not going to get the justice that they deserve or that they need because they're a minority. Reason being, if you've never been to 79th Street and you don't understand that it doesn't work the same that it works in Evanston, you will put an Evanston rule and try to make it work at 79th Street. Right. So, of course, that doesn't work for that person. That doesn't work for that family. But if the judge doesn't know that, the judge is not familiar with the area, the judge doesn't really care and wants it to work this way, that's the way it's going to have to work. So, unfortunately, when you're a minority there, if you don't have the right kind of judge, a judge that's going to be caring and going to be concerned and worried about your family, you're going to oftentimes face that unjust ruling.
So let me ask you that, because that's great insight, and what that makes me want to pause for this question is, does the judge have leeway, flexibility in sentencing or making decisions in family court, or are there statutes that the judge must adhere to regarding that concern with fitting an Evanston solution on a 79th Street situation?
You know, much of what happens in family court is at the judge's discretion. When it comes to the money, for the most part, that's statutory. But sometimes, again, they don't look at necessarily, okay, you have a wife and your wife has money that she has come, but they may not look at, you have 8 other families. That's a real thing for some families. They have other families that they're supporting. So not every judge will look at that. The statute gives, oftentimes the statute gives judge very broad discretion to do things. And unfortunately, even if you appeal that, the appellate court doesn't overturn something unless it's a gross abuse of discretion. And that's hard to find. The judge can make a reason why this works. And again, it's all about the situation. What's the situation?
So as an attorney facing that with a client that has those circumstances before them, how do you make that appeal to the bench for the judge to actually hear the client's case, and then actually rule in a level that is commensurate with the situation in real life and show consideration and compassion for those clients?
It's very difficult to do, but it depends on who else is in the case too. Oftentimes, if you have an attorney that understands the actual scenario you're dealing with, you're able to negotiate something that works for that family. And that's assuming you can get the family on board with understanding, listen, this can be resolved between you two. This is your life. At the end of the day, you can decide how your life's going to flow, or you can let the judge decide how your life's going to flow. I always try to encourage my clients to be the person in control of your life. Divorce doesn't mean the end of this family. The family still has to function, right? Even though you're going to take this family and separate it into 2 households, it's still a family that needs to function for the best interest of the child or children. So the other thing that we have sometimes, there's oftentimes in a highly contested case, a child rep that's appointed, which is an attorney for the child or children. Those persons sometimes are the eyes and ears of the court. So they're oftentimes able to come back and let the judge know, well, judge, that's not going to work here. Here's why. And they'll give them a list of reasons. And oftentimes the judge will take those recommendations. But again, it depends on the interest of the judge and the care of the judge. If the judge is not really interested in trying to clear a docket, then you're kind of stuck with what you get. And appellate court is not an option for everybody. It's very expensive. So if you're poor,
right, you take the first ruling,
and you barely got in here, you can't go to appellate court. It's not a whole lot of people that go to appellate court for family law because they can't afford it, even though their rights have been violated or the judge didn't follow the statute. They just can't afford to go there. So now their family is stuck to live in what the judge put on that paper.
Wow. So what I'm hearing you saying, Maria, is that, or Ms. Barlow, is that when the 2 opposing parties come to an agreement, that can take the judge out of the equation.
I don't want to tell you it can take the judge out of the equation, but I tell my clients like this. If you negotiate your own settlement, you get a lot more want than don't want.
I understand.
When the judge has the rule, you get a lot more don't want than want. The judge still has to sign off on the agreement.
Right.
But it is most likely that the judge will go along with the agreement unless it is unconscionable. Then they won't. But for the most part, when parents are negotiating parenting time, I always tell my parents, look, please be in charge of this. Like, this is your job, this is your life, this is your schedule. You need to keep up with it. So you don't necessarily take the judge out, but you are more in control of what it is. So you might want to do Wednesdays at 3, and the judge has already told you it's going to be Wednesday at 5. But you know 5 o'clock doesn't work.
Right.
But guess what? You either better figure it out or it's going to be 5.
Okay.
And judges do that. I mean, it's not uncommon.
So for those of you at home who are following this interesting conversation, please don't forget this is an interactive show. Please call in with your remarks or comments at 312-738-1060. That, again, is 312-738-1060.
Okay. Ms. Barlow, I'm getting a divorce. Do I need an attorney?
People ask me that a lot. I always say it depends. everybody will benefit from a consultation, because oftentimes you don't know what the law is. You've heard this, you've heard that. It's usually wrong.
Yes.
Or at least that's been my experience. Most people who have heard something is wrong. But you oftentimes also want to make sure that you've covered all your bases and that you have the proper documentation and that you're doing the proper thing. Yes. If it's not a very contested divorce, I've encouraged clients to go ahead and resolve it between themselves. They don't necessarily need an attorney. If everything's agreed, there's not a lot of assets and things like that. You know, I tell them I don't need to insert myself into a case that you all are able to resolve. I'll help you with the paperwork.
Yes.
So oftentimes I find myself helping clients with paperwork versus trying to do full-on litigation for two people who know this is ended. I want these days, you want those days. I want these items, you want those items. They're pretty much done. Okay. They just need help with the paperwork.
Right.
So they don't necessarily have to hire a full attorney. I don't want to say a full attorney, but attorney for full service. But if you can get your documents done and make sure your judgment is correct, because that's the thing you have to live
right.
with.
You can
you may not need.
Right. At that point, the attorney is an advisor.
Right.
Okay.
And you help them with paperwork. Okay. You want to make sure the paperwork is clear. It makes sense. So we know, all right, it's not just that we're getting spring break this week and that week. We know it's going to be spring break at 2 o'clock, and it's specific. Attorneys are very specific in detail. Okay. So you want to make sure that that's the case, that you know exactly what you're doing. Because families break down over time. There's fights. Things happen.
Okay. In a case like this, I would need a quandra spes to call for litigation.
It depends on your issues. You might need a quandra space if you're ready to litigate.
Thank you.
You definitely do.
Okay.
Small nuance to that scenario that Robert just presented.
Yes.
Do couples need to go through a separation prior to divorce?
Yes, the statute now says that you're supposed to be separated for 6 months. But like I explained to my clients, you could be separated, live in the same home, right? There's nothing in the statute that says separation means that you have to be living outside of the home. There's nothing in the statute that says the separation has to be written on a piece of paper or legally separated, anything like that. Guess what? I tell my clients, at the moment you knew you were done and you're separated, you're separated. Many people live in the same home for 2 or 3 years before they get a divorce, because that's what they choose to do.
There's different criteria to establish separation.
Yes.
There's different ways to
absolutely,
right.
And it's not necessarily that you don't live together anymore. There are many couples I have clients I represent, and they live in the home together and they're separate. They're getting a divorce.
Wow.
Yes.
Interesting. So we're just playing rapid fire, because I think some of these questions out here that we are going to ask you today are important for our viewers and those of you who are watching and listening, because we think that these kinds of issues need to be addressed at all different levels of family law in the practice that you have. So, for example, do grandparents have visitation rights? We want to talk about the children. So, can grandparents establish visitation rights to their grandchildren if there is a situation where the family starts to unfold, separation, divorce, what have you?
Grandparents do have rights, but it's in limited circumstances. So, for instance, mom and dad have broken up, and mom and dad don't really like the grandparents. Then no, grandparents don't have rights in that scenario, because mom is there, dad is there, and they both don't like this grandparent. So that grandparent would not have rights to see that grandkid, because the court assumes that parents are going to make good and reasonable decisions for their children. However, you have a situation families have separated and one parent is deceased. At that point, grandparents' rights kick in, or one parent is incarcerated or missing or something like that, or even deployed. That person is no longer available, and so the grandparents' rights then kick in.
So where we see a lot in our community where grandparents are, in a lot of cases, the primary caregiver for their grandchildren, because of the division of families and the breakup of the black family over the last 50 years, in those cases where we see it, in textbooks, sometimes there isn't a legal situation that has placed that grandparent in that role. As you said, through deployment, a deceased situation, or what are the parents?
It's two different statutes.
Right.
So it's two different statutes. So with the grandparents' rights statute, that's usually when the one parent is unavailable. Then you step in and say, hey, if my child was here, then I would be able to see my grandchild. But because my child's not here, I need to see my grandchild. Court, help me. However, in a situation that you're describing, that comes under almost like what the parents will go after. I am here. I'm acting as a parent, even though I'm a grandparent. So court, grant me rights under that.
Can you
It's
hold
a
that
different
grandparent?
right.
It's fascinating.
Wait for one. We have a caller on. Caller?
Hello?
Welcome to the show. What's your comment?
Sure. Quick question. In this scenario, what you were just saying, what happens if the mother and the father, they split? The grandparents has much financial to take care of the grandkids. Now, he been taking care of the grandkids all along. I mean, they stay more at his house than they will stay at the parents' house. Can the grandparents, would they legally have to adopt the kid, or would the courts allow for the grandparents to keep the child? So that's the question I'd like to ask. And let me get out there. Thank you.
Thank you for your question. Maria?
So that's a little bit of a complicated question to answer. Reason being, I need to understand who's contesting, right? If mom and dad just don't want to be bothered, then of course the grandparents can step in and take the child. However, if it's been a short amount of time and mom shows up and wants the kids, or if dad shows up and wants the kids, they have superior rights. Parents always have superior rights. Unless the grandparent can show, hey court, this parent or these parents relinquished their custody or their possession of their child to me, the grandparent. And so now I have standing to stand in the shoes of a parent and proceed and come and take custody of this child. We don't have custody in Illinois anymore, but I use the term custody because most people are familiar with it. But that's what a grandparent would proceed under, saying, hey, they left them with me, so now I can stand in the shoes of a parent and get and make this child my own. They wouldn't be adopted, but they would have custody of that child,
So,
if granted.
So the custody stage is the preliminary step to an adoption, which could take place later, right? If in fact those rights were relinquished.
Adoption is a different court, and a person doesn't necessarily have to relinquish their rights, but they kind of relinquish possession. So for instance, I think it's in an Illinois Supreme Court case where the parent dropped the child off and left the child for like 6 years and then came back, hey, I want my kid. The grandparents then had standing to fight and say, no, they turned this child over to me. They knew that this child was here with me. They never came back. So court, please give me this child. I've been here as the parent for 6 years.
Ms. Barlow, how has the law changed in Illinois as it relates to grounds for custody, divorce, and child support?
Okay, so we've had several changes over the last few years, and I anticipate a new one as it relates to parenting time. So we don't have custody anymore. Everybody gets bogged down on custody, joint custody, sole custody. We don't have that anymore. Now what we have is allocation of parental responsibilities and parenting time.
Yes.
So everybody's getting parenting time. You're going to have the child these days. I'm going to have the child those days.
All right.
Everybody gets that. And then there's the allocation of parental responsibility is just decision making. One parent or both parents together, or one or the other, will decide what the child's going to do as it relates to education, as it relates to health care, as it relates to extracurricular activities, and as it relates to religion.
Okay.
So those are the things that parents go to court now and kind of fight over, if you will. Oftentimes I see now, without the term custody, a lot of people aren't fighting as much over the term custody because it doesn't exist. They do sometimes fight about parenting days,
Yes.
but it's not as contested, I don't think, since they removed the term custody from the statute. Even child support. Child support is different now too. Used to be if you had one child, you paid 20% of your net income. If you had 2 children, you paid 28%, and so on and so forth.
Those are statutory levels.
Per
Per child.
parent that you have a child with.
Now back to the grandparent for a moment.
Sure.
Let's say you have a 5-star grandparent. The grandparent's excellent, but the parents does not want the grandparent involved with the children's lives.
The parents are entitled to do that.
Okay, so the grandparent doesn't have can't go to family court to.
No, because they wouldn't have standing. The court assumes that the parents are in the best possible position to know what's best for their child.
Excellent.
And both parents are saying, no, 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 not this grandparent.
Right.
That'll be very hard to overcome. There's a specific set of criteria that must be met in order for a grandparent to petition the court and be properly before the court.
Okay.
So I have a quick question here. Is there an age at which a minor child can choose which parent they want to live with? What age of when does that age begin?
The child doesn't necessarily get to choose. But at about 14, I see courts. Okay,
Good. I have a caller, and get back to that
Sure.
real quick. Okay.
Caller, what's your question? Thank you for joining our show this afternoon.
Hello?
Good afternoon. Thank you for calling. What's your question?
Yes, I got a comment. This is a great show. I wanted to congratulate Mr. Brutus for that show. But I have a comment. Since I am bilingual, we have a lot of legal issue in our community, the Haitian community, Creole speaking. I'm wondering if those beautiful attorney and Mr. Brutus, you can address certain sensitive issue pertaining to immigrants in your show. That will help. But this one is great, and I enjoy it. Thank you very much. Keep up the good work.
Thank you.
Thank you.
So, to answer the question, do we have any situations where you've encountered, a family situation with an immigrant family?
These situations happen with every family.
Right. So, should we
Rich
say
family,
do
poor family.
immigrant families, let's say non-legal immigrant families living in this city, do they have rights in the courts, and are they recognized by the court?
Absolutely, they have the same rights as everybody else. They're in the court. They're properly before the court on whatever issue it is. They're going to get the same rights as everybody else. The only time that I see, and please don't quote me on this, every attorney is going to have a different experience, but I have seen situations where if there is a risk or a fear that one parent or the other will flee the country with the child, I have seen judges take the passports. And the judge will, if there's an attorney in the case, they'll have the attorney hold the passport, or they'll have the parent in fear hold the passport, or the court itself will hold the passport.
Right.
They'll do something to make it.
Okay, one question for me is that, well, this recent proposal by the president to take the children once they come across the border.
We're going to hold that question for part 2. Hopefully we can get you back in the studio, Ms. Barlow, as we have to wrap up. So we've enjoyed our time with you today. I think and hope that all of our listeners and viewers learned a great deal about family law, how it's impacted the black community in the 50 years since the Kerner Commission report. And if you want to know what's going on with Maria Barlow and her practice and need her consultation or her services, please reach out to us at help1save1@hotmail.com, and we'll be sure to let you know her personal information or her work professional information so we can reach out to you and you can talk to her and consult with her. Otherwise, we thank you, and we hope that you join us next week as we have another exciting topic for you on CAN TV, Help One Save One TV. Thank you very much, and good night, Chicago.